Hi, this is Jessica Organ, and I attend the University of Findlay, getting my Master's of Arts in English, Rhetoric, and Writing. Today I'll be discussing a paper that I wrote for one of my courses. The title of the paper is called Pedagogy in Law School, Studying Cicero's Ornamentation as a Key Factor to Legal Advocacy. This paper first establishes the importance of oral ornamentation in the legal realm, using one of Cicero's speeches, then proceeds to discuss the importance of law schools offering a class for oral ornamentation, as law schools currently lack in this area. The argument is built up by using Cicero and his speech labeled the First Oration against Catiline. The main establishments are as follows. 1. There is historical truth in oral advocacy. 2. The legal pedagogy focus is too narrow. And 3. The repercussions are manifold. In result of not teaching law students oral ornamentation, there are many issues that arise, not just in the legal realm, but in society and in the field of rhetorical studies. The main notion is that Cicero and his works are a prime example of why it is so important for law schools to teach oral ornamentation in law school classes. Action needs to be taken to resolve this issue and create attorneys that truly know how to advocate for their client. In return, the inclusion of oral ornamentation in law schools will also build the rhetoric back into legal studies, as it has been lacking in recent years. When most think of advocacy, specifically those that are not familiar with the actual law, the image appears as if being a good speaker and being a good attorney go hand in hand. This is not by any means a fair assumption. A person who is obsessed with Judge Judy will be greatly disappointed if they attended a legal argument of the local or state level. The fact is that attorneys, while they know and understand the law, do not know how to advocate unless they have received years of practice or attended a top-tier law school. That's not only very expensive, but also very difficult to gain admission to. Most law schools do not offer a class on how to represent a client by speaking well. Rather, the focus is on the actual law itself. If a student chooses to get their feet wet in oral advocacy, their real option is to join moot court or mock trial team in their first year at their law school. This poses many threats to the reliability of the law and legal representation, as well as to the field of rhetorical studies due to the fact that so many regard oral ornamentation and legal representation as a joint package. This results in the field of rhetorical studies not being something held with the same high regard that it was held to when Cicero was looked up to for his practice. To give some background and context, in the first oration against Catiline, Cicero accused and proposed further action against Lucius Sergius Catilina in treason against Rome. This speech was the first speech of 4 conducted in which Cicero accused Catiline of treason. Cicero conducted this very long and complex speech, urging Catiline to leave the city by manipulating the audience using the rhetorical appeals. His speech was successful and resulted in not only Catiline leaving the city, but also his execution later on. The 3 major parts of his speech were as follows. There is nothing more than Catiline can do, because Cicero knows all of his moves. Cicero instructs Catiline to leave the city, and he compares Cicero to Catiline to capitalize Catiline's defeat and Cicero's victory in the Senate. Every single move that Cicero made in his arguments dealt with the fact that he was without a doubt completely and entirely correct, and the opposing side was completely and entirely incorrect. Every single part of his argument was correct, and his was the absolute truth. He manipulated the way that the audience felt using humor, fear, and anger. The way in which he developed the speech was thought of with the utmost consideration. He even used words with negative connotations when discussing the opposing side and associated himself with words with positive connotations to manipulate his audience. The idea of us versus them is very prominent, as Cicero makes it clear that you are either with me or with him, and if you are with him, then you are wrong. He does this in the very beginning of his speech when he talks directly to Catiline. When, O Catiline, do you mean to cease abusing our patience? Although Cicero makes the insightful decision to speak directly to Catiline, Cicero has made this rhetorical movement thinking about the wider audience than just who he is addressing. The use of "are" is where Cicero distinguishes a side, while he is also accusing him of doing something harmful. that pairs the two together. Repetition is another tool that he would implement to manipulate his audience. With this speech, he relied very much so on rhetoric and not on logic. The list of his rhetorical appeals with ornamentation can go on and on. Arguably, one of his most prominent tools is the idea that if you were overload accusing someone of doing something, the audience may not agree to all of them, but they will likely think that the man must be guilty of something. Look at all that he's been accused of. To quote, "The Senate is aware of these things, the council sees them, and yet this man lives. Aye, he even comes into the Senate. How dare he even live?" Although he did charge Catiline to leave the city, he went further from this and questioned his audacity to be alive right now. An audience might think it cruel to question his life, but what about his place of residence, especially when the charge is treason? In fact, this speech drove Catiline to willingly leave the city, and there was not one accusation that Cicero implemented in his speech that dealt with actual hard evidence. If Cicero is capable of running a man out of their own city without using any hard facts in his argument to the Senate, imagine what attorneys who deeply understand the law could do. Moving on to historical truth in oral advocacy. Historically, oral ornamentation is highly received in the art of persuasion in the legal representation of clients. Cicero is very well known for this skill in oral ornamentation and being able to speak well. During his time, he was able to bend the minds of those that were listening to believe that he was saying the correct thing and that they should, in fact, agree with him. The power of ornamentation is very obvious. As in the field of rhetorical studies, a man who was born centuries ago is still a very powerful person in the art of rhetoric. This man, very prominently known as an attorney, preferred to be remembered instead as a philosopher. Therefore, it is clear that ornamentation, specifically legal ornamentation, has immense power. It is a complete shame that the majority of law schools are not studying it. In fact, at most law schools, the focus is on the legal text, which is obviously a very important component. However, law schools do not teach how to talk, and they definitely do not teach how to advocate. The lack of pedagogy dealing with how to advocate is a major problem, and for many practicing attorneys who do not have the natural ability to speak well. In speaking of Cicero and his mother, a research note on ancient Greek inscription and the study of classical rhetoric, Enos notes that Cicero is very highly regarded and deeply studied to better understand the history of rhetoric. Centuries ago, law was not as well defined or well precedented as it is in today's society, and we still study and come across an attorney that is very highly regarded solely due to the fact that he could speak or argue well. As proponents in the field of rhetoric and writing, we know the importance that words have and the power that comes with using them well. However, this is not something that attorneys may readily understand, and it does not benefit them or the field of rhetorical studies. Words do have power, and Cicero has been studied for thousands of years to use them. So much so, that we are still studying his life today in order to better understand the history of rhetoric. Even at a young age, Cicero was considered a patron of rhetoric and literature. Someone who was so prominently known thousands of years later actually valued rhetoric and literature above the law. His powerful use of rhetoric as an attorney is what made him so highly regarded. Oral advocacy, as Cicero demonstrated in legal cases, are crucial to the decision of a close case. It is a crucial part of advocacy, yet most law schools have not yet been trained in legal ornamentation. Studying oral ornamentation is crucial to being able to represent a legal client to the best of attorney's ability. Past the obvious benefit that lawyers would be better advocates, it's more important to also mention that clients would in turn receive better representation. Better representation might lead to some overall bigger truth that appears and begins to help society build back their trust in the fairness of law. Let's move on to the legal pedagogy focus being too narrow. Law is beyond the casebook. There is a reason that law is studied as law, and oral ornamentation is not always the key component. Law is entirely about finding an objective truth. Legal scholars are worried about an objective truth, swaying an argument to the client's favor. The same can be said about the field of rhetoric. It is clear that most writers do not understand or possibly even care about legal or political issues. If Cicero made the same speech he did years ago, today, in the United States court, much of his argument would be thrown out on grounds of hearsay and relevance. Attorneys not only understand the law, but they are ingrained in it. They care about the legal field the way that writers care about ornamentation. The best way to consider this is to find a happy medium. But the issue lies in the fact that law schools are completely ignoring the fact that oral advocacy is so valuable. And it is just that, valuable. Writing classes in law school do not even discuss rhetorical moves as much as they discuss how to write about and how to use statutes, casebooks, law reviews, or case law. This notion is not something that is necessarily new. While most either ignore it or don't care about it, those that critically think how we can become better lawyers or how we can fully use rhetoric question and extend this idea. In Step Away from the Casebook, A Call for Balance and Integration in Law School Pedagogy by Stanchi in 2008, this exact concept is expanded. It's not surprising that this article is one from Harvard University by a law professor that teaches a legal writing class and feminist studies, someone who understands that there is immense importance in both areas. Stanchi argues, students must learn about these theories in a context that shows them how theory connects to practice and how to use theory in practice. It's a breath of fresh air to see someone make this argument when most law professors really focus on law as if it's the be-all, end-all. Young attorneys, directly out of law school, they can objectively agree that they understand the law, but they have absolutely no idea how to advocate. It's a shame to see years of hard work and money be spent to become an attorney who has no idea how to advocate. It is especially a shame when we have such amazing resources like the works of Cicero available to study for this specific purpose, and it is ignored or discounted. Furthermore, in Truth in Action, Revitalizing Classical Rhetoric as a Tool for Teaching Oral Advocacy in American Law Schools, written by Hannaran in 2003, this idea is not only recognized, but expanded by the proposal of future action in comparing Cicero to a modern-day attorney that argued a landmark case, that of O.J. Simpson. In fact, Hannaran goes on to say that Cochran, which is O.J. Simpson's attorney, and Cicero used the same rhetorical appeals. One example is the use of repetition and rhyme. Cicero is well known for using these tools as a means of persuasion, and Cochran does so by coming up with a well-remembered saying, "The glove doesn't fit, you must acquit." Even this case occurred over a decade ago, and it's a saying that's still remembered. It makes logical sense that simply by using the tools Cicero used in oral advocacy, we get this type of result. This in turn supports that Cicero's rhetorical tools need to be studied to receive better advocacy in a modern-day setting. There is no reason whatsoever that we should not be held at this standard. While in modern day, Cochran is considered an amazing attorney. This should be the standards that all lawyers should be at, using Cicero to better argue and better orally advocate for their clients. The problem we are facing in law schools is detrimental to our society. Both Cochran and Cicero relied heavily on the use of ethos, pathos, and logos to persuade their audience. If you ask the average law student to think back to their undergraduate freshman English class, they would likely not even be able to define those or what they mean or interpret how they could be used in an argument. This is a serious issue. Further, Cicero, through his many works, discussed the importance of not only why he incorporated, but also why it must be incorporated specifically in legal cases, as discussed in Hannaran's 2003 article. It is a great mistake to consider the speeches we deliver before the courts as a faithful depository of our personal opinions. All these speeches emanate from the cause and the circumstance rather than the man and the orator. For if the cause could speak for itself, there would be no need for counsel. We are therefore called upon not to utter our own maxims, but to bring out everything of significance that the cause can furnish. That is the importance of oral ornamentation and legal advocacy in a nutshell. The importance here is not one that should be overshadowed. Using the appeals and the senses, we must paint this image of what occurred to our audience in order to achieve the justice that we so greatly desire. How? Please tell me. Do we argue without using these appeals effectively? This is the only solution. Moving on to the repercussions. There have been many cases in which attorneys have been sued or have lost their license because they did not represent their clients to the best of their ability. This is known as ineffective assistance of counsel, and it is a major issue. We have attorneys that are going through years of law school and spending loads of money to achieve this dream of being an attorney, but the education system fails them. And they end up being stuck with understanding the law, but not understanding how to truly advocate for their client. Clients are left with attorneys that do not know how to argue and do not know how to represent clients to the best of their ability. The reputation of attorneys falls into a category of untrustworthy or uncaring, and they are not looked at with the same high regard as Cicero. These attorneys, who actually use Cicero's tools and his logic emerge, such as Cochran, and they are held with such a high regard. They have the trust of their client because they are advocating for them to the best of their ability. Cicero has made this clear through not only the demonstration of his speeches, much like the first oration against Catiline, but also the explicit statements he has made in regard to this particular topic. In Summit, Taking the Offense Forward, Public Interest in Lawyering and Law School Pedagogy, written by Rodriguez in 2003, the public interest was discussed in depth in regard to how law schools teach and what exactly they teach these future attorneys. Service to the public is a high calling, and one that should not be taken without much thought and consideration. The needs of the public need to be addressed, and we must advocate for them with the highest regard. Attorneys are told that they must zealously defend their client, but not that they must zealously advocate for them. If law schools truly valued their students, the public, clients, and justice, they would teach their students to zealously advocate for their clients, using the works of Cicero, specifically by studying the tools he implemented in the first oration against Catiline. To wrap up into the conclusion, law schools need to take this issue to heart, truly understand and take action to this, and to actually doing something about this monstrosity. It is a problem that is affecting many, even those that are not in an academic setting but need the representation. Historically speaking, the power of words and how they are spoken or written, changing the way that people look at the context of an issue, is very real. We study Cicero to this day to understand the powerful rhetorical moves that he took to be so well regarded in rhetorical studies, but it is entirely disregarded in the aspect of legal studies. Let's take a note from Cicero and his works. Let's go as far to even argue that law schools should be banned and shut down from teaching law without the teaching of rhetorical tools in Cicero's speeches, as it only produces attorneys that do not accurately advocate for their client to their full potential. Let's extend this further, like Cicero would. Those that are attorneys and do not understand the importance of rhetorical tools should be charged with ineffective assistance of counsel and lose their license to never be able to ruin the life of another client or shatter the reputation of other attorneys that deserve such a higher regard. Maybe now, after implementing Cicero's logic, we will finally take some action.